What's up, everybody? Welcome back into another episode of the Lawyer You Know podcast. And today I'm really excited about the guest we've got on, who was one of my favorite lawyers to watch in trial for a bunch of different reasons. And we're going to get into that in the interview, what I think makes him so good at the specific trial law he practices, and I happen to practice as well. It's Kevin Binyazin from the 6-year-old school shooting trial where Abigail Zwerner was the victim, and they secured a $10 million verdict, which, if it sounds like a lot of money, that's because it is. In this case, it was a lot more difficult and a lot more complicated than it may have seemed for anybody that just watched the trial and picked it up there, which I know a lot of us did. So we're going to dig into that case. We're going to dig into his background, ask a lot of the questions you all had for him during the trial. Let's get to it. Kevin Binyazin, welcome in.
Good morning. Thanks for having me.
Yeah, man, I'm excited about this because when we get a civil trial, that's, one of my favorite things. People, joke on the channel that I'm just a civil lawyer because so many of the cases we handle are criminal. But when this one popped up, it was interesting from the jump for a number of reasons. But first, congratulations. How did it feel when you heard the number and you heard the verdict?
Thank you. And thank you for having me on. Candidly, it's always just a relief. There's so many emotions going through your head, especially when you're sitting there and you're waiting for a verdict to come in. And so when you hear that it's first on your side, at least for me, there's kind of an exhale. And then you obviously wait and hear what the ultimate outcome is in terms of the number, but it's a relief, and it was just a total exhale. So yeah.
Yeah, there's nothing worse than the hours or days it takes waiting for the verdict. You did kind of simple math, and I do want to talk about damages eventually, probably later on. But sometimes when you've got medical bills and they ask for a calculator, that's always my first exhale, and I'm like, okay, good. At least they're calculating some numbers for us. But so it was a great feeling. I know it was years of hard work. But before we get into the trial, even the biggest question on everybody's mind in my chat was, how old are you?
I am 33 years old.
Okay, because that's what they were saying. They're like, the young lawyer. I really like the young lawyer. So how did you get to be a managing partner at a successful civil law firm with, I don't know, probably hundreds of millions of dollars of verdicts and settlements? How did you get there at 33?
Yeah, good question. I mean, I give a lot of credit, and I have a lot of thanks to give to my partner, Jeffrey Bright. I was a law student at William Mary Law School here in Virginia, and he was a professor of mine, an adjunct professor. And he, for whatever reason, good reason or bad, he plucked me and decided to hire me at his firm at that time, which was Bright Drescher and Prevento in the Virginia Beach area. And sort of, I got an early start. He threw me into the fire, and I tried 6 juries in the first 6 months of my practice, all by myself, all the verdict, and kind of looked up and said, okay, I think I can do this. And I think I can get into a bigger pool now and start swimming laps and testing my skills. And that kind of led one thing to another and more cases. And I've been fortunate to try some very significant cases and some high profile cases even before this one. And yeah, I mean, I think ultimately, if you put your head down and you focus on the craft, which I appreciate that you focus on in your YouTube videos and your show that I've watched. If you focus on the craft, I think when the opportunities are presented to yourself, you have an opportunity to take advantage of them.
Yeah, there was definitely some times throughout the trial where I think you even mentioned people call you a nerd when it comes to like the evidentiary arguments and things like that. What are some of the things that you like to focus on? Why do you like the evidentiary arguments so much? What got you into that? What do you continue to do to work on and hone that craft?
Yeah, I think I was an evidence nerd in law school. I just think they're really interesting issues, and I am a young lawyer, but I tell younger lawyers that work at our firm and at other firms, I say, there are certain things in the practice of law that don't change much. You can learn the rules of civil procedure, you can learn the rules of evidence, you can read those cases, and you can be just as good or just as intelligent on those issues as somebody who's been practicing for 30, 40, 50 years. That's not something that requires experience in a courtroom per se. And so earlier on in my career, I tried to make sure I mastered the things that I could master, right? And so if there are things like the rules of procedure or like the evidentiary rules that I could read, memorize, understand better, then I thought that that was a leg up because I may not have had you know, the there's a bad word for this, but this blank house sense in the courtroom, when
Mm.
you're in the courtroom and trying to figure it out. And so even to this day, I think I try to focus most of my time on what's the priority. And I think the priority is being better at what I do and being better at what I do as a trial lawyer. And so it may not mean reading the rules of evidence or cases as much, but I am a nerd in the world of like cognitive science, and I try to adopt these different philosophies and theories, both in psychology and in sales and cognitive science, to try and figure out a way that I can be a better trial lawyer. And my firm and my teammates often joke that I'll say, "Oh, there's a book that I read," and then give them a little piece of advice. And so spending more time in the work and not just talking about the work, I think, is the most important thing.
Yeah, it's and when it comes to evidence, people don't know. I think they're learning more as we watch cases before trials even start. How important it can be to keep certain evidence out or get certain evidence in, and that really doesn't change that much because I did a lot of criminal work early in my career, a lot more civil now. But I've tried probate cases, small claims court cases, and guess what? The rules of evidence travel with you everywhere. Now they can be a little different depending on the jurisdiction. I've tried some in federal court and state court, but if you know the rules of evidence, you can control that courtroom, control what comes in, and it helps you prepare, right? You know what questions you're going to ask that might get objected to, what evidence you're trying to submit, what those objections might be, and you can foresee a lot of the arguments coming. And it seemed like you dealt with that in the trial a lot with some of the major evidentiary issues, some of the testimony they wanted to bring in about what happened after the fact and what people were saying about what happened before, yet you were focusing on the information they had at the time of the shooting and leading up to the shooting. So to me, I felt like that was a big leg up for your side versus the other side, but you were the youngest lawyer in the room. And sometimes, at least it seemed like that, there could have been a younger lawyer there, but sometimes certain lawyers try to play bully ball or try to say push you in one direction or the other, maybe not even in this trial, but have you ever dealt with that in the courtroom before, and if you have, how do you deal with it?
Of course, I mean, I think it still happens. I was in court yesterday and in a significant case, and there was a joke that people refer to me. It wasn't a joke, but that I had a appellate counsel there with us, and they said, "Do they intentionally call you by your first name?" And I say, I'm pretty sure they do. All this psychological warfare that people think that is effective. And
Yeah.
my view of it is, and it's kind of consistent with what I've already said, which is if I'm really good at what I do, and if I focus on the craft and the skills and the tactics, then I don't have to worry about the noise around me. And so my view of it is, people people throw mud at me. They still do, and I was the probably the youngest trial lawyer in that room, and I've often still been the youngest trial lawyer, unless I have an associate at my own firm whom I'm trying to kind of bring up the ranks as well. But I think if you focus on the work and not get bogged down in what they're trying to do, which is trying to play me. I'm playing the game and they're trying to play the player. And if I can play the game and they're focused on the player, then I'm going to win at the end of the day.
Yeah, and that's the great thing about trial work and the law and the rules and the judge is it really a lot of that noise doesn't matter, especially once you get in front of a jury. I mean, that's the best place to be where all of that goes away. And now it's just these 6 to 12 people that don't know any of us, don't know our experience, and we're putting on the case. And when you're doing the plaintiff side, you get to choose which cases you pick, and which ones you don't, and which ones you take to trial and which ones you don't. And so, from our perspective, like you have the story you get to tell. And when it came to this case, I have a feeling that the story started and the work started way before trial, as most of them do. And a lot of us jumped in and watched the trial. But what were some of the major issues and hurdles you had to get through just to get this case before a jury?
Yeah, I think that if you ask folks in the legal community, especially in Virginia, this was kind of a lame duck early on, and that's because we have a very stringent workers' compensation bar in Virginia, which means that you can't sue your employer or co-employees, but for certain exceptions. And so we knew from the outset that we would be asking the court to recognize this as essentially an exception to that limitation in bringing a lawsuit. And that's where we focused a lot of our energy early on. We also knew that if and when we overcame that hurdle, we'd also have to face what is still alive and well in Virginia, which is sovereign immunity. And so the school board, I know that there are a lot of questions, at least friends and family have told me a lot of questions online about the school board and the
Hmm.
school system. And so we knew that we were going to have to get over the comp issue, and then we'd have to get over sovereign immunity, or at least get past it somehow and navigate through it. And then, we had a coexisting criminal case at the same time, which we knew would or could result in delay in our case. And so it was, there was a lot of chess moves, to try and get us to where we were in that, October trial date of 2025. And, fortunately we overcame a lot of the hurdles. We lost some as it relates to sovereign immunity, which we can talk about. And ultimately, uh, we've what I think you asked me earlier, how did it feel to get the verdict? It was a relief. It's also a really gratifying experience as a lawyer to think, okay, we've actually charted a new path for people to potentially recover in circumstances like this. And I think that is something since the verdict that has probably struck me the most in terms of, you know, this issue of being able to sue a co-employee as a teacher. It was really not attempted in Virginia or elsewhere. And so, there were hurdles, and we navigated them as best we could.
Yeah, and you could feel a lot of that, and a lot of people were asking questions like that in the trial. So I wonder what the jury was thinking. I'm sure you dealt a lot with this in jury selection, but let's take them kind of in turn. So the first one you talked about was work comp,
Yeah.
and just to make it on as basic of a level as we can for anybody listening, most work comp scenarios is you get hurt at work. Let's say you work at McDonald's, you get hurt at McDonald's. They have work comp insurance, they pay for your medical bills, but you can't then go and also sue McDonald's because that bars it by work comp. But if somebody were to come in to McDonald's, a patron, and punch you in the face and you get hurt while working at McDonald's, you can still get work comp from McDonald's because you got hurt at work, but a third party is at fault, the guy that came in and punched you. So you can sue that third party. But in this scenario, because it's a co employee also at work, how did you guys get through that and navigate it? You said you kind of used some exceptions to be able to continue forward. The drier it gets outside, the more I love today's sponsor, OneSkin. The cracking of my hands goes away, and the face cream that they have is absolutely amazing. And that's because at the core is their patented OS01 peptide, which is the first ingredient proven to target senescent cells, the root cause of wrinkles and loss of elasticity, which are all signs of skin aging. And what's great about OneSkin's products is they're certified safe for sensitive skin. OneSkin products are free from over 1,500 harsh or irritating ingredients. They're dermatologist tested and have been awarded the National Eczema Association seal. OneSkin also just launched their limited edition holiday sets, including the Nightly Rewind gift set, which is one of those rare gifts that's both impressive and genuinely useful, providing an upgrade to anyone's nightly routine. Featuring their best-selling face moisturizer, their new peptide lip mask, and a cooling gua sha tool. Each component of the set is designed to work together as your body enters its natural nightly repair mode, helping renew skin at the cellular level for a stronger, smoother, and more resilient skin. For a limited time, try OneSkin for 15% off using code LYK at oneskin.co/LYK. After your purchase, they'll ask where you heard about them, so please support our show and tell them we sent you.
Yeah, so I think that was a great summary. First of all, the way that we overcame it in this context is that there was some case law in Virginia before this that talked about whether something was an expected injury on the job, and if it wasn't expected or part of the job or part of the job description, so to speak, then arguably it didn't fall within the confines of the workers' compensation statute.
Mm.
And then additionally, there are other cases that sort of talked about how in the event that something was personal to an individual, that is a way for the courts to distinguish what is expected and not expected. And what we mean by that is, if there's a type of injury that happens more commonly across the board to people, even if it's not something that you would see routinely, the courts say, well, it's it it's not routine, but it seems like this is something that happens enough that it's not personal to the employee. It is a more general risk to the population of workers in this class. And so our theory, and I believe it to be true, and it proved to be true in the court's rulings, and we may have to deal with this on appeal later, is that what happened on January 6th, and the reason that the news cameras, and we're talking about it likely today, is that it was totally unexpected, right? It was not expected that a school teacher, at least a school teacher for first graders, would be shot by a first grader, and that first grader would make comments that effectively reflected that I did this to you. I meant to do this to you particularly, and that is reflected in some other evidence that didn't really come up at trial because it wasn't pertinent. But because of those balancing factors, we felt, okay, we think that we can really pursue this justly and rightly and say that, okay, while there may be some risks involved, and when we argued the workers' compensation statute, I remember the judge had asked me in oral argument, well, what makes this case different? And I said to him then really what I said in closing argument, which is a gun changes everything. And the gun, we wouldn't be here if we're talking about a student that threw a paper clip at somebody and scratched their hand, or took a pair of scissors and threw it across the room and injured a teacher. What we're talking about is a gun, and the gun is unexpected, and the gun was personal to Abigail Zwerner. And that's ultimately what the court reasoned in deciding that the workers' compensation statutes in Virginia didn't bar the suit. So we overcame that. And at that time, it was both against the school system and the co-employees. That was the first thing that was really heard.
Yeah, and whenever you have a big decision like that, that is kind of groundbreaking, it's awesome, it's exciting, you're doing legal work, you're in the trenches, but there's also always in the back of your head, like, those are the ones that get appealed. Those are the ones they feel confident appealing, as opposed to, like, I just had a verdict appealed last year and everybody knew it was going to happen. But of course, they have to appeal it because they're going through the process because they don't want to pay. So it's like, there are different appeals. And those appeals, we had a case, I don't know if you heard anything about it, the Take Care of Maya Netflix docu-series was here. Huge, hundreds of millions of dollars in a verdict, some strange rulings that kind of got us there, but you can understand where the judge was coming from, and the whole thing gets overturned and now remanded back for another trial. So, those are kind of when you have groundbreaking things go in your favor, but you get the opportunity to get it in front of a jury and see, what does society think about this? And so many people had the question throughout the trial, like, what's the difference between a teacher getting shot and a student getting shot? And kind of what you explained is the difference in how there wasn't really an avenue before, to go through it because of workers' comp. But how did you deal with, the sovereign immunity, all the other parties that were involved? Because there was some mention of that, in some of the legal arguments, I think, when you guys were arguing that there were other parties and they're no longer here, so that's not relevant. So tell me a little bit about how, the procedural history there with the sovereign immunity and the other parties.
Yeah, so the court eventually ruled that the school board, the superintendent, and the principal were all immune under sovereign immunity. And it's interesting because since this case was filed, there have been a series of decisions by both the appellate court and the Supreme Court in Virginia on the scope of sovereign immunity for school boards specifically. We don't need to get too much into the weeds, but school boards are kind of this weird quasi city, quasi Commonwealth governmental entity because they're sort of created by statute through the Commonwealth, but they're funded through the city or county budgets.
Okay.
And so there were sort of questions of, okay, does it get the same immunity as the Commonwealth, or does it get the same immunity as a city or county? And in Virginia, those are different, believe it or not. And so for years, there have been sort of different decisions that made it so, and we felt quite strongly that we could overcome sovereign immunity for everybody. And then there were recent decisions that came back down by the Supreme Court that clarified it in a way that I don't necessarily agree with, but that's why I'm not on the Supreme Court, and clarified it in a way that was not advantageous to us. But what it did clarify, which was an issue, was that even if an employer like the school board is absolutely immune, for a tort or for a harm like this, the individual employees of that entity are only immune for simple negligence and not gross negligence. And so it was ultimately that the court ruled that everyone, including Dr. Parker, were immune, but that they were only immune for simple negligence, and that the conduct on the pleadings of Dr. Parker were sufficient to go to the jury on the issue of gross negligence. And that's how we got where we were.
Yeah, and you could tell that was a big deal, right? And that was obviously, it was almost like, and again, it's tough sometimes for defense attorneys. It's almost like they were trying to argue she was negligent, but only simple negligence or general negligence versus gross negligence. And I
Right.
think sometimes it's hard for a jury to be like, something this horrible, you're admitting she screwed up, but where is the line on what's simple negligence versus what's gross negligence? And that right there to me, a lot of times comes down to lawyering. So it's like when you're really nitpicking and trying to explain to the jury what the difference is and teaching the jury because, I've had friends on juries, and I've had jurors talk to me after cases, and they're like, how is it possible that I show up and I'm a insurance salesman or a college referee, and now I've got to figure out how to be a juror in like the most important decision in someone's life? It doesn't seem fair, but that's part of the job of a lawyer, is to teach the law to the jury and tell them how the facts kind of marry to the law, which I thought was a really huge part of your presentation and the defense's presentation. What was your thought, kind of, how am I going to get this through their head that it's gross negligence versus simple negligence?
Yeah, I think first, I think when you're talking the law to people who are not lawyers, y- you have to talk with them and not at them. Is my view. It's not like you're lecturing them like you're their professor. You're not their professor. Nobody signed up to take this class.
Mm-hmm.
They're held captive, and they're trying to do the right thing, and they want to learn it in a way that they can apply it. And so it's not enough, in my view, to just say, this is what the law says. Now go back and use the law, because they're looking at it going, well, I don't know how to use that. Like, I've never had to use anything like this in my life. It's like giving somebody a complicated IKEA manual and telling them to build, the entire furniture in their house, and they've never done it before. And so I think that, uh, my view is that we learn through metaphor and we learn through analogy better than we learn through anything else.
Mm-hmm.
And we also learn through imagery and the application of imagery in our life experience, so that we can correlate what we've experienced in life with the thing that we're being asked to do in the present moment. And so I identify certain jury instructions that I know or think will become important in the deliberation room, or are certainly important to our case. And then I think about, how do I explain this in a way that they've probably made this sort of analysis. And so the baseball analysis in terms
Mm-hmm.
of what's negligence and gross negligence, I've used that before. That's not the first time I've done it, but it's in my view, it has become the most effective way that I can tell people what's the difference here. Like like because it's still throwing a baseball, and that's how I feel. And you asked me about, how do you talk about gross negligence or negligence. At the end of the day, the decision that a defendant makes is often the same decision. It's not doing something or doing something poorly, but it's what makes it gross or willful or reckless, in my view, is what's the likelihood that something bad is going to happen, and you still choose to do that thing. And so that's why I like the baseball metaphor in sort of explaining that. But I think ultimately you have to find a way. You have to find metaphors and life experiences of jurors to tell them or show them, this is what this means. We just have fancy words for it, but you do this every day in a different capacity.
Yeah, and I really liked how, a lot of the repetition about, not once, not twice, she was told this time. It wasn't just one individual thing, which I think is also a good differentiator for negligence, where it's like, yeah, it still would have been a screw up if it was just one, but it wasn't. It was this, and you kind of stacked it on top of each other. And I like people that do PowerPoints with pictures and graphs and graphics more than just a bunch of words. We didn't get to see all of yours through closing arguments, and a lot of times I listen versus watch, but
Yeah.
So I enjoyed that you can kind of use it. It can be an outline without an outline, having pictures up there instead of words. And I'm a no notes guy, so I like that. I respect that. I don't think it's the only way to do it. And people have gotten on me when certain lawyers, read their closing, and I'm like, that's not my favorite way to do it, but I understand it can still be effective. But I really enjoyed that, and I think it's hard to get the jury to understand some principles sometimes when in their head they probably automatically go to just general negligence. And that's generally what they think of, whether it's a car accident or something else. So to get them to kind of see that high bar for someone that is not not yet, maybe the criminal in the case, the perpetrator, the tortfeasor, the wrongdoer, the shooter, right? That can be pretty difficult too. And I thought you guys kept a lot of that discussion out. In Florida now, the law just changed that in negligent security cases, or I would assume in a case like this, I've never tried a case exactly like this, that the shooter's name would be on the verdict form and we would have to argue the difference in percentage of fault, including the shooter. What's the law like in Virginia when it comes to that?
Yeah, I practice a lot in Arizona, and
Okay.
that's how it is in Arizona. You get essentially a third party at fault on the verdict form. But in Virginia, Virginia still has joint and several liability, and and there it's a contrib state. Although contrib doesn't apply in this context, it sort of educates or informs a lot of the law here, which is that there is no third party on the verdict form ever. And the only way that somebody gets on the verdict form is if they're pled in some way to be a party in the case, either a third party defendant, plaintiff, or an actual defendant in the case. And so there is pretty good law in Virginia about eliminating, and we probably talked about this at some length during the trial, about eliminating the empty chair, or making sure that there is no discussion or there's no pointing of the fingers to somebody who's not actually a party to the litigation. And so that's good
Which they
law.
were kind of trying to do with the other teachers, like, oh, Mr. Rawls or this person, they knew all this and didn't do it as well, which you guys differentiated in, like, they knew this, she knew all of this kind of thing.
Yeah, and I don't think you'd have to tell me. Did Court TV pick up the voir dire? I don't think they did jury
No,
selection.
I did not watch it. I don't know if they
Yeah.
picked it up, but I did not watch it.
So that was a big part of uh, questions that we asked in jury selection, and there was a jury questionnaire that asked them about their impressions and et cetera. And there were some folks who reflected that they had concerns or that they felt like a situation like this starts at home, for example. Like, are the parents are going to be
So
involved?
many people in my chat, so many people said the same exact thing. Like,
Yeah.
where's this kid's mom? How did this happen with this? Starts there. Then, kid, how are we at the school level? How are we dealing with an assistant principal? So many people ask that, which I always think the chat amazingly is such a good representation of like general jurors out there. And again, they'd get struck in a lot of cases like this, but that's really interesting. So you guys dealt with a lot of this, which makes sense, right? If they're going to put it all on mom or they're going to put it all on 6-year-old, then they might not be right for this jury.
Yeah, and so the way that we tried to address it in voir dire is I said, look, when we get involved in these cases and we get into a courtroom, sometimes there are folks that you think might share some responsibility in what happened. But ultimately, you're being asked only to decide what responsibility, if any, there is of the person here. You're not going to be asked to compare. You're not going to be asked to contrast. You're not going to be asked to weigh the differences. You're only going to be asked to say, did they do something wrong that you found was culpable? And then was that a proximate cause? And then I sort of explained to jurors, what does that mean preliminarily? You can have multiple people be a proximate cause. It doesn't have to be a single person. And so we knew that that was a strategy that they were going to pursue, whether it be the boy, whether it be the other teachers or whoever, parents, for example. And and so we tried to front load that thought process and get affirmation from jurors. Hey, I know you said this on your verdict form, but if you decide this case, or you, uh, and I say to jurors, I say, look, I'm concerned. Do you understand why I'm concerned? I'm concerned that you'll get into this case and you won't be able to put aside the parents, and they're not going to be here. You're not going to hear it from them. I'm worried that that's going to be knocking on the door in the jury room, trying to make its way into your decision when we know that it can't. is that a fair concern? And some people will say it's a fair concern. I don't know that I can get rid of it. And some people will say, I hear you. I can separate that. And I say, okay, if you're telling me that you can separate that, I accept that. And there are jurors that sat on the case that said exactly that, that said, I think it starts at home, but I can separate that. And they sat on the jury and ultimately rendered their verdict.
If you're looking for Christmas gifts and whether or not right now you consider yourself a last minute shopper or if you're ahead of the game, today's sponsor, Aura Frames, is a great option that's different and something that literally everybody can enjoy. And it really feels personal because you're giving somebody the opportunity to put unlimited photos on a digital frame anywhere in their house. It is so incredibly easy to set up and use. I wish I wouldn't have already given my daughter one because it'd be the perfect Christmas present for her. Maybe I'll get one for my niece who is the same exact age. You can upload the photos straight from our phone or anything you could download their app on, and it is so seamless and easy, and unlimited photos that she can have scrolling. She put it to go to sleep at a certain time in her room, so it's on in her room as she goes to bed, but not on all night, lighting up the room. So many cool features on it that really set it apart from some other digital frames out there. For a limited time, you can save on the perfect gift by visiting auraframes.com to get $35 off Aura's best-selling Carver mat frames, named #1 by Wirecutter by using promo code LYK at checkout. That's AURAFrames.com, promo code LYK. This deal is exclusive to listeners, and frames sell out fast. So order yours now to get it in time for the holidays. Support the show by mentioning us at checkout. Terms and conditions apply. Yeah, it's so interesting dealing with all of that. I'm sure another thing you had to deal with at some point in jury selection was gun control. That was another thing a lot of people want to talk about is the laws. We need to change the gun. I'm like, I understand that and people have their views on that, but that's not going to affect, we're already here. So now we're dealing with this and the fault that lies in this trial. How did you deal with that in jury selection?
Yeah, it was on the questionnaire, but I will say that the judge in pretrial motions also indicated that that really wasn't going to be what we're trying this case about, and sort of headed off some of that
Okay.
in motions in limine practice. And from our perspective, consistent with what you said, it really wasn't about that by the time the gun's on campus, right? Like, if by the time the gun's on campus, it is what it is, and you got to deal with the threat as it's
Right.
posed at that time. And so there were questions on the questionnaire asking people generally what their views were of gun violence or experiences with gun violence or gun control. And it was helpful to get a sense of what people's understanding or appreciation of the issues were, but it wasn't really determinative for us because we knew it wouldn't come up in earnest during the trial.
Yeah, and I meant to ask this when we were talking before about, whether it's mom or son, um, and you don't have any third parties on the verdict form, which is great, but there's a little bit of a trade-off here that's much, much worse in Virginia than in Florida. And I think Arizona too doesn't have the 1% rule. Like if she's 1% at fault, that bars all recovery, which is the craziest like law of all time to me, because I've had cases that where they're almost admitting fault and the jury will still put 10% on the other party for whatever reason, right? Huge number, but 10% because it's some kind of compromise back there so that we can get a unanimous verdict. But you guys made it clear, or actually the defense made it more clear than you did, I thought, which is helpful because it's like, if you want us to win, you can't put even 1% on her. If you think she's 1%, she loses. So is that really what you want? Which almost just sounds like a verdict for the defense. But how do you deal with that 1% rule?
Yeah, it's the way that it's just the way that life is in Virginia, so I think that, look, I think ultimately you have to frame it in the context of it's not doing a thing that is contributing 1%. It's doing a wrong thing that is contributing a 1%. And in cases, I didn't focus it that much on this closing argument, but there were parts where I think in my closing I said, look, their job was to sound the alarm. They were the watchmen and they did their job. Now you've got to do your job. And that was sort of uh, an ode to this idea that they satisfied what requirements there were of them, including Miss Warner, of doing what she was supposed to do. She was non-negligent. But a lot of times what you see in Virginia is that a defense lawyer will come up and they'll take a piece of paper and they'll rip off the corner and they say, even if she's this percent at fault, then she cannot recover any of the piece of paper. And we've dealt with that in different ways, and I think if, to your point, if the jurors internalize, okay, what is the true result of the decision of making a contributory negligence finding? I think it allows them to see things in more clarity and say, okay, let's really make sure we're applying this appropriately and not just saying, oh yes, she did a thing that was 1% at fault, but let's say, was it a negligent thing? Was it a wrong thing? And there's an instruction that I think I talked about in rebuttal that I often like in cases like this, which is that that a plaintiff has the right to assume a defendant is going to act in due care, and therefore when somebody is sort of expecting that somebody else is going to do their job appropriately, it's not negligent for them to be waiting for somebody else to do their job. That is allowed. That's allowed in the law.
Yeah, and I really think that human beings generally, this is not like a cut to jurors to say they like things simple, but human beings generally like to simplify things. They don't want to overcomplicate things, especially if they're in an uncomfortable position or making a big decision they've never made before. And I've always thought that whole 1% rule, our state has tried to push it because we used to, it's going in that direction for us too. But I've always thought it's just their lobbyists use it so that so that insurance companies and defendants can use it in negotiation more than anything. I've only got to prove 1% and you lose, because I think once you explain the principle to the jury, 1% means they lose. So 1% is 100%. It's kind of simple. It's kind of an either or. You're still picking a winner. And I think if you simplify that to the jury, it can really work in your favor more than sometimes, just a normal contribute where they're putting a certain percentage on your client. So I think from my perspective that you guys handled it well and the jury understood that it was all or nothing. Basically, it wasn't five. Okay, let's say 5% she was at fault. They weren't going to do that analysis back there, in my opinion, which I think is helpful for you. Um, Probably the number one question that people had throughout the entire trial, because they hear 40. We actually heard $40 million from like a news article, but we didn't hear you guys say $40 million until closing. And then I think when you were doing your closing, you mentioned that you said something about $40 million in voir dire, which makes sense to connect it all up, because I've always been of the practice of, you don't want to shock them in closing. Like, you want them to know what's coming, whether you do it in opening or jury selection. But the number one question everybody had before we get to how you ask for money, which I, as just selfishly, want to hear your take on that. Who's paying? How is Dr. Parker paying $40 million? She probably doesn't have $40 million, and that's no knock on her. Most people don't have $40 million as they sit there as an individual defendant to pay a big strapping lawyer like you who's asking for all this money. Like, how is that possible? Who's paying $40 million? How do you deal with that with a jury?
Yeah, so she's covered by the same insurance policy that covers the school system and the school board. And that policy, I won't say what it is, but it is more, there's more coverage than the verdict. I'll put it that way.
Nice.
And so we knew that she would be covered, as when we were talking about all those machinations of how do we get to a trial, and how are we going to get there, and who's going to be at the table. Of course, you want we do think that there is some culpability at the school system level for a lot of the reasons that we got here, and there's more about the Newport News school system that we don't really have time to talk about. But we knew that as long as we had one of the employee defendants at trial, that they would be triggering an insurance policy that's provided to them and the school board through the Virginia Risk Sharing Association, which is essentially a pooling insurance entity for public entities. So different cities and counties and stuff pay into this risk sharing association, which is essentially an insurance policy. And so that's there are issues. I think some of the press has covered a little bit of this, which is that there are sort of bluffing or threats from that entity that, given the fact that she has criminal charges pending against her, that they think or might pull their insurance coverage as it relates to her acts. I work in this space a lot. I represent a lot of abuse survivors, which is most of it. But you mentioned negligent security cases, so third party crime. I represent a lot of sexual abuse survivors where this is a big thing, where insurance companies try to claim, oh, well, what happened ultimately is a criminal act. And because it's a criminal act, we don't have to provide insurance coverage, even though we've sold you the insurance coverage. And sometimes you have to fight about that and have a whole different case about insurance law and deal with that a different way. But you know, I think it's just thumping of their chests at this point and trying to use different strategies to try and lessen the recovery. But short answer is there is insurance. She's covered by the same policy.
Is it publicly funded or is it a normal insurance policy? Like, meaning, because again, a lot of the people in the chat want to know, are you just asking for the jurors' own money that they're putting into? Does that affect how much they're going to give? Because it's like, wait, it's the school board, public, maybe they know about this insurance policy. Are you just asking me for my own money? Is that going to limit how much money I'm going to give you?
It's a really good question. Answer: no, it's not dollar for dollar in that way. Of course, the school system is paying a premium for the
Right.
policy, and so there is dollar. And I've tried cases. I tried a case in a small town against a power cooperative, and that was a big concern I had. And in voir dire, we sort of said, look, if you sit on this jury, are you gonna consider the fact that, are you going to be concerned of the fact that the verdict in this case, however much it might be, may actually affect your bottom line as somebody who uses power and electrical services from this company? And people were honest and said, yeah. And there was a juror during jury selection who said almost exactly that. And she essentially said, well, where's this money coming from? It's a
Mm-hmm.
public school system. And you deal with it as best as you can without telling them the things you're not allowed to tell them.
Joe, tell them without telling them the truth. We can't actually tell them the truth, so we've got to find a way around it to not prejudice our client without telling the truth.
Yeah, and I think it's, you can't tell them the unadulterated truth. A
Right.
lot of times they say, look, I hear you. we what's most important, and I said this in jury selection to folks, what's most important is that your role in this case isn't to decide how it's paid or where it comes from. Your role in this case is to decide how much it's worth. And as much as we want to think about the other things, that's not what you're going to be asked to do. But if that's going to affect your decision, and that's going to be knocking on the door in the jury deliberation room asking to come in, then we need to know that, because that might mean that you're not right to sit for this panel and you're not right to make this decision. And that's okay.
Yeah, and I think you dealt with that in closing argument. You said you can't worry about how Dr. Parker is going to pay for it, and there was an objection, I think, during their closing argument where it maybe seemed like they were trying to say, like, look over there at Dr. Parker, how's she going to pay for this, or something like that. And there was an objection, I think, during closing. So that's obviously always a big question when it comes down to the jury, especially when you're asking for this much money, which is always difficult, right? And you did it in a way um, where there wasn't a life care plan, there wasn't, past medical bills, there wasn't something specific to point to with a receipt to say, okay, let's start here. She's this old, we're going to go. I know there was some talk of that, but with, future surgeries, but lost wages, whatever. It's kind of bulky numbers is what you went with, and buckets of numbers. I like to use buckets as well when I do, and I talk about getting the full value of the loss and the harm. And how are you what was your strategy in asking for $40 million, knowing that's a lot of money? How can you convince a jury it's worth that amount of money? What's kind of going through your head, especially when, honestly, from my perspective, when I watched the trial, I thought Abigail Zwerner's testimony was pretty quick. Like, I thought, not that you want to draw it out. I'm a big keep it simple, stupid plan as well when I go to trial, which you guys pared this down beautifully, in my opinion, and made it not boring at all until it got to the defense's case. And we had all these days in between. But when it's that kind of simple and short and sweet, do you worry? Does this feel like a $40 million case? It's holiday season, and with the same types of meals that always go with certain holidays. So I love mixing it up and lightening it up with seafood. Problem with seafood is you never really know what you're going to get unless you order from companies that you can trust, which is where today's sponsor, Wild Alaskan Company, comes in. They're 100% wild caught, never farmed, which means there are no antibiotics, GMOs, or additives. Just clean, real fish that support healthy oceans and fishing communities. They're nutrient rich and full of flavor, and they're sustainably sourced. They're wild caught from Alaska. Every order supports sustainable harvesting practices, and your membership can deliver flexible shipments, expert tips, and truly feel good seafood. The salmon is honestly my family's favorite, but we haven't had any that we don't like yet. Plus, if you're not completely satisfied with your first box, Wild Alaskan Company will give you a full refund, no questions asked, no risk, just high quality seafood. Not all fish are the same. Get seafood you can trust. Go to wildalaskan.com/lawyer for $35 off your first box of premium wild caught seafood. That's wildalaskan.com/lawyer for $35 off your first order. Thanks to Wild Alaskan Company for sponsoring this episode.
Yeah. Yeah. I'll start by saying, we strategically did not choose to put in any economic numbers.
Mhm.
And that doesn't have too much to do with this case as much as it has to do with my experience. I've pulled economics on trials, I think, for the last 4 or 5 cases that I've, tried, and fortunately I've had very successful verdicts in doing so. And I think it's a to me, it's we can't make per diem arguments in Virginia, which means
Mhm.
that we can't say this is worth $10 an hour and let's multiply $10 an hour for the rest of her life, or $1 a day. Those are prohibited. And so when we have the economic numbers, in my view, the best way to make use of them is by trying to make a per diem argument, and then you run the risk of doing something potentially that the Supreme Court is not going to like or say is not permissible. And so I like to focus, and I tell them in jury selection, I say, you're not going to hear at any point in this trial anything about pocketbook losses. You're not going to hear about economic things. You're not going to see a spreadsheet that says this is how much she owes in medical bills, or what she's lost in wages. We're only going to be asking you to decide what is the value of these human losses, these harms and losses that she's experienced, other than those that you can see on a spreadsheet. And then your job is to actually put them on a spreadsheet. Can you do that? And and then when we get to the decision making at the end, I think that is a hugely important role for the lawyer. Like, I think being able to talk about damages and being able to explain why or how do you get to this number, where does it come from? Why are we talking about money in the context of somebody being hurt and harmed? I think all of those things are to me a lot of. It sounds weird to say, but it's fun. I enjoy trying to talk about kind of those philosophical issues in the
It's
law.
the
And
art, right? It's the art
yeah,
when you talk about it versus the science of just like, here's how much a medical bill is, give us this amount of money.
yeah, it's fun, and you get to really tap into what you believe in, and I believe in it, right? Like, I genuinely do, and I think I think it's totally true that there's no amount of money that she would replace to go back to what had happened, and the way she was before. And then the hard part is to figure out, okay, well, is that 40 million? Is that 30 million? And and we in Virginia, you have to pick a number that you sue for, and you have to put it on the complaint when you file the lawsuit, and you cannot recover more than the number you sue for. And so even if the verdict came back at 50 million for whatever reason, we wouldn't be able to recover 50 million. We'd only be
Interesting.
able to recover 40 million. You're
Mhm.
essentially arbitrarily capped at the number you pick. And then naturally, because of that, there's press coverage oftentimes that circulates around that number because it's an easy story for the press to pick up and to talk about. And
And
so,
when you say that, you mean to make it seem like money hungry. Look at these
yeah,
lawyers trying to get 40 million. Abigail Zorner's just trying to get a lottery ticket. So when you say the press picks it up, it's they always want to make it look like, something nefarious because of how big the number is when not under or when people see, other cases that have the jurisdictional limits and they're like, they're only suing for $30,000. I don't understand that. So it's part of what we do here on the channel is to kind of explain how that works. So I'm glad you told me that. I didn't know that's how it worked in Virginia.
yeah. And so that number, we thought was would be righteous if the jurors return a verdict for that amount of money. I also recognize that it's unlikely when you're asking for a specific number that the jury is going to actually return. it's happened to me before, but
Yeah, I
the,
agree. Then you're like,
the
"Why didn't I ask for more?"
yeah, and I was like, okay, well, thank you very much. But and so I don't know if I answered your question, but I think it's trying to get jurors to appreciate that this is a daily experience that you're processing this through. And we can't, there's a slide sometimes when I'm teaching other trial lawyers that I show them, and it's a woman like looking through the peephole of like a door. And I use it to say our job as trial lawyers is to take an hour or 5 days or 2 weeks. And what we have to do is communicate a lifetime of experience in that 2 hours, in that 30 minutes, in that 10 minutes that you're talking about damages. Your job is to explain a whole lifetime of experiences. And so you're just giving them a little vantage point through that doorway to try and see what it's like and then make a decision off of it. And so I try to walk them through those experiences, and then sometimes I try to walk them through what the future looks like a little bit. And that's why I use the metaphors, or when you throw your bed off, you throw your feet off the bed of the table. And we all have that feeling when we can take an inhale and know that the cold is gone, and she's never going to have that. It's going to be with her forever. And so those are little ways that I try to give them an imagery when they get back into the jury room and they are starting to debate what it's worth. They can go, well, what about the thing that it doesn't go away? Or what about that moment when she was laying on the carpet floor in the administrator's office? Or what about, what's that one moment worth? And then trying to build off of that.
Yeah, no, I feel I hurt my shoulder the other day, and it's so depressing to think like, is this ever going to go away? And it started to feel better. I'm like, okay, good. Light at the end of the tunnel. I get back on the golf course playing pickleball again, and to think she's never going to feel that, it's a great one. That's a great one. I loved it. So yeah, you answer my question. And to me, it's just really interesting. Different people's philosophy on asking for a lot of money. I've waived past meds. I've never waived future before. And honestly, I think it's you have that good experience, and the first time was probably really nerve wracking. But having an anchor, knowing you feel like you're going to win and the jury's going to give you something because you're positive they can point to it, and even jurors that might not like you are not going to be able to argue against certain economic damages. So I think we can make some per diem arguments in Florida. But yeah, that's a really interesting kind of philosophy. And then you can ask for bigger numbers, and if you've got the jury and you've got a good client and a good case and you get there, I think that's really interesting. And obviously it worked in this case. One other thing I wanted to go back to real quick was, even on cases where it's not, suing a school board or feeling like public money, where it's, taxpayer dollars, jurors still talk about, in my jury selection, as I'm asking, do they do this in yours as well? Even if it's just a car accident or truck accident and it's an insurance company, and they're thinking, because here in Florida, so many lobbyists and people in the media are saying, this is why your car insurance is so expensive. This is why your homeowner's insurance. This is why milk is so expensive, because these trial lawyers with their big verdicts. And I've had jurors or potential jurors say things like that and open up a full discussion about, do you really think this is why your life is so expensive? And is that going to affect your verdict? Do you deal with that in normal cases, or just the taxpayer dollar type of cases?
No, I think to your point, it comes up all the time. 2 week. I was in a trial 2 weeks before this one in Virginia Beach, and we were trying a case against a roadway construction company, and they had it was a messed up a sort of traffic thing, and there was a head-on collision with our client when somebody went the wrong way. And in the back of my mind, I thought, okay, they may think, to your point, that this is public money because it's actually a public work project, but we're only suing the private entities.
Mm-hmm.
But nonetheless, it still comes up even when you don't want it to, or implies you don't want it to. But even when you're not asking for it to come up, in the context of that voir dire, we didn't even intend to bring it up in that way. But it was, I think somebody had said something to the effect of, on this topic of tort reform or lawsuits,
Mm-hmm.
and they said, these lawsuits are driving up the cost of life, and then you talk about it, and I think, I'm sure if you've had other trial lawyers, I know you've had on your program, I hope that others have said this, but as long as you have a true and authentic view of those principles as a lawyer and can engage with that person in voir dire in a way that is that is true, that is like, not like you're trying to tell them what they want to hear, I think you can overcome it. And it's that one person may not actually sit on your jury. You may decide to strike that person, or they may be struck for cause or for what other reason. But what you have is you have 30, 40, 50, 60 other people watching you for the first time, trying to gauge, okay, who am I going to follow here for the next week and a half? Who am I going to trust when things get tight and things get narrow? Who am I going to who's going to guide me in the right direction? And so when those types of things come up, sometimes I tell jurors, I say, look, I hear you. I don't agree with you. Obviously I do what I do for a living and I don't agree with you, but I totally hear you. I totally understand it. And I'm sure there are other people in this room that do agree with you, and who here does agree with what John said about the cost of life going up because of these lawsuits. And let's have a conversation about it, because I think I have seen trial lawyers say, that is true, that it does do that. And I'm going, well, why are you saying that if you don't believe that? Right. Because there's this desire to
Yeah.
build like a rapport or something. And so I know you didn't ask me that question, but I wanted to
No.
flag that and say that.
I love it. And I love that person. It's happened to me multiple times. I love that person. I'm striking them every single time. But I love that person because it's going to
Yeah.
get the conversation. I mean, we all have friends, right? I can assume, Kevin, you've got a couple friends. They all don't agree with what I think about this stuff. And I've had these discussions with my friends who I respect and I love, and we agree on a lot of things. But that's how it's going to be when you're picking a jury. And I've busted panels because of that person, which sucks. And then case gets continued and whatever, because mine are just normal cases, not high profile where they have thousands of jurors waiting for me. But yeah, it's just, I like that person because I like the discussion. I like disagreements. I like differences. I also like to know which jurors are going to stand up and say, no, I don't think you're right. I think that's this person because that's probably a juror I'm going to love. Because they're willing to stand up in a crowded room of people they don't know and share the other side, which I happen to agree with. So, it's a very important part of the process. So I like learning from you and listening to you kind of talk about how you deal with it. That's fun. That's kind of part of the point of this channel. Okay, the last section I want to talk about is the criminal side of it, which you brought up. One
Sure.
big reason we know is kind of the insurance looming. They're going to pound their chest, which, by the way, if you've noticed so many ways, we've talked about how, there's appeals processes, there's the 1% rule, there's trying to get out of paying even if you lose, if it's a criminal case. And all the reports were the criminal trial was supposed to start like right after this trial ended. Was that strategic on your part, trying to get this trial done first before she was convicted of a crime? The criminal trial has been continued to May, I believe, of 2026. So you don't have that issue now pressing, but was that part of your thought process on when to get this trial done?
Candidly, no.
Okay.
What was part of our thought process is not allowing the calendar of that case delay ours,
Mm-hmm.
because I have been in situations where there's,
Oh, yeah.
parallel criminal cases, and you have no control over that docket. You have no control over whether that prosecutor is ready, or whether the court is ready for that case, or whatever. And I'm not talking about this circumstance specifically, but
Yeah.
and so the real push in pretrial motions, and there are a lot of motions for continuance on that basis leading up to trial, was we don't have to dictate how we do our thing with how they do their thing, right? And we can do this separately. And I think that criminal case has been continued. It's probably the third time it's been continued. And so in that respect, maybe that had an effect on the court in terms of not being too persuaded by that trial date. But I've had it the other way. I've had judges say, we're going to wait until the criminal trial. And
Yeah, I
then
was going to ask, did they even try to stay? Did the defense try to stay this civil case for the criminal
they
case
did.
or no?
They
Okay.
did. Yep.
Well, good for your
Yes.
judge.
Yeah. So the judge denied the stay early on. And then as the case got through this summer, there were repeated motions for continuance, essentially saying, we know that you didn't stay the case, but this criminal trial is set 2 weeks after this civil trial. Why don't we continue the civil trial until after the criminal trial? And
Mhm.
our position was, we don't know if it's going to happen. What we do know is that we're ready to go try our case. So let us go try our case. Let them figure out what they're going to figure out. On the insurance stuff, I think I hope it's not inevitable, because I don't think it's righteous and I don't think it's right. But it's inevitable if that's the litigation path, or if that's the pursuit that they want to take. We'll hunt it down until the end. That's kind of the brand and the reputation of our firm, and you're sort of in it from the beginning and you're in it to the end. And so if we've got to fight this, as Winston Churchill says, you've got to fight it on the beaches. If you got to fight it in the air, if you got to fight in the sea, you just got to fight it.
Yeah.
And then you got to find a way to win at the end of it.
You guys know I'm a little bit OCD. Well, here's a gross fact. Traditional bed sheets can hold more bacteria than a toilet seat. Yeah. Not exactly what you want to put your face on, but today's sponsor, Miracle Made, has bedding that is designed to fight bacteria and stay cleaner longer. They have silver infused fabrics that actually prevent up to 99.7% of bacterial growth. So thanks to that antibacterial silver technology, Miracle Made sheets stay cleaner and fresher up to 3 times longer than regular sheets. That means fewer odors, fewer wash cycles, and way less laundry. So upgrade your sleep or give the gift of better rest. Go to trymiracle.com/lawyer. You'll save over 40%. And when you use the code lawyer, you'll get an extra 20% off plus a free 3-piece towel set. They make an amazing gift, and with a 30-day money-back guarantee, there's absolutely no risk. That's trymiracle.com/lawyer, code lawyer, LAWYER, at checkout. Thanks to Miracle Blade for sponsoring this episode. And I know there was some, discussions about Dr. Parker pleading the fifth and that coming out in jury selection. Another thing, I mean, people don't realize, again, I always talk about how jury selection is the most important and sometimes my favorite part of trial, because I feel like I have a pretty good gauge on how it's going to go after jury selection's done. Not like we always know what a jury's going to do. It's always a risk, but I like in state court in Florida, we have so much interaction with the jury. In federal court, almost none. Like I'll submit a list of questions and the judge is like, no, I'm not going to ask those, Mr. Tragos. I'm like, okay, great. So it's much more difficult. So I love the opportunity to be able to talk to the jurors. So how was that dealt with? And was that also something that you considered waiting till after the criminal trial? Because then, it wouldn't necessarily work the same. And in Virginia, I think you said that there is an adverse inference if somebody pleads the fifth. How did that work in jury selection?
Yeah, so we didn't want it mentioned at
Okay.
all. And part of that was because we didn't know whether or not, and we had no affirmation from opposing side whether or not she'd actually take the stand and whether she'd actually plead the fifth.
Okay.
And so in our positions pre-trial, it was, well, why are we gonna insert these things? Like, why would we? And it almost felt like I was fighting for Dr. Parker. I'm going,
I was
why?
going to
Why are
say, did you not want it just for the complexity issue? You didn't want just to add another layer to it? Is that why you didn't want to talk about it?
Yeah, I think it invited an issue for the jury to have to think about that they didn't have to think about,
Okay.
right? I've tried cases where there were criminal charges either pending or that there was an acquittal, for example, of a criminal case of a defendant of mine before we went to trial, and we've asked questions on questionnaires where it's essentially tell us what you know about stuff from the press and then explain it, and then based upon what they answer, we get a sense of whether or not they know about criminal charges, for example,
Mm-hmm.
and then you can maybe talk about it. But the defense insisted on having this question about the Fifth Amendment and the question about the pending criminal charges on the written questionnaire, which meant everyone was going to get it, regardless of what the substance of the Q&A was. And so it really put us in a weird position because it was implied that she had pled the fifth, but under Virginia law, that's not how it works. You actually have to plead. You have to take the stand. There has to be a question asked of you, and then you have to plead the fifth. And then the judge gets to decide whether that's sufficient or whether the question is sufficiently incriminating such that you can plead the fifth or not. And so I thought it was a little bit of it was strategic on their part, I suspect, to try and insert the issue in front of the jury without actually having to take the stand and plead the fifth. It played out how it played out.
It just seems that almost seems backwards to me. Like in most of my cases, I want the defendant to plead the fifth, especially in a case like this, because I'm thinking if I'm a juror and she's got criminal charges pending, if that's what I'm putting together from her pleading the fifth, that feels more like gross negligence than just regular negligence, right? People don't go to jail for just regular negligence. It must be really bad if the cops think that's, I feel like most of the discussion and a lot of the people in the chat were talking about it too. Like, I feel like the plead the fifth discussion is actually good for the plaintiff, but you guys are the ones that didn't want it. And the defense was the one that did want it. Almost seems backwards in this case, and I know you tried to deal with it in rebuttal, just like, that didn't happen here. That's not an issue in this case, is basically what you were trying to say, right? I mean, what was your point of that of argument? Is just like that's not an issue for you to think about, or what?
Yeah, the whole point is you decide this case based on the evidence and the circumstances that happened in this courtroom. And we told you that in jury selection. And guess what? That's not here. That's not something for you. You can't go back in the jury room and think about that because that didn't happen. Never happened. And and look, I like to answer your question about why, if it benefited us, why would we want to not address it?
Sure.
You know, I try to try a clean case as best as I can, knowing that there are inevitably things that people will pick apart. Personally, with the way that I practice, that's common, and generally in the nature of the cases that I try, it's contentious. And so, to the extent that I can avoid an issue that I don't think is going to have a significant effect or a material effect on the outcome, I like to avoid it. And in this situation, I thought that it was a little bit disingenuous as we were getting to the end of the case that there was this floating question of that issue of this Fifth Amendment that was not addressed and never came up in the courtroom.
Could you have called her and asked her questions that she pled the fifth to? Are you allowed to do that in Virginia?
We could have called her. Yes, we could have called her. In Virginia, there is there's some case law from the Supreme Court of Virginia that essentially binds the plaintiff pretty tightly to what the opposing side says if they're called as an adverse witness. And so strategically, I try not to call an opposing party as an adverse witness in my case
Hmm.
because I don't want this extra layer of appellate review, if that makes sense.
Okay.
There's like this extra level of scrutiny on the plaintiff's case if they're
Hmm.
relying upon an adverse witness to demonstrate the evidence. And so, in the event that I can get the case on without having to call the person, that's what we wanted to try and do. And the other thing is, I didn't want it to look like I was trying to vilify her,
Mhm.
and in the sense that I'm putting her on the witness stand just to make her plead the fifth, right? And if we didn't know whether they'd call her or not. We were honestly, I had a cross examination ready, just waiting to go in the event that they called her, and then they didn't, and it sort of played out.
Yeah, and I think what's really interesting about you, just spending an hour with you, is you're obviously able and capable of handling all of the complex and difficult issues prior to trial in order to push your strategy at trial, which is to simplify everything in front of the jury, to tell them what you believe to be the truth and the honest picture of the story. And you believe that if you do that, they'll give the proper result and verdict in the case. And that probably allows you to, sleep well at night, where it's like, listen, I presented everything to them as fairly as I possibly could. I didn't try to overdo anything, didn't try anything underhanded, wanted to make sure they knew what they're deciding this case on, put it in front of them as simply and easily as possible, not overdo anything, but also not underdo anything, and then just let the chips fall kind of as they may. It feels like that's what your strategy is. And I was shocked at how quick the case was. I loved it that it was so short, because I can't stand so many of these cases, especially some of the criminal cases we watch, or some of these prosecutors that have been prosecutors for 20 years put on every single witness you could ever think of that might say one thing the same as five other witnesses. You guys really didn't do that. I thought you put up the evidence you needed, and obviously it was enough to get the result that you want. Is that kind of a fair assessment of what your trial strategy was, at least with this trial?
Totally. I mean, I think there's a saying that I'll butcher, but I, where the guy says, "I'm sorry I didn't write you a shorter letter, but I didn't have enough time." And
Exactly.
and I
I
think
butcher sayings all the time. That's my thing. So
and
thank
I
you.
think that that's totally. I think that is advice that I give other trial lawyers, which is you once you're in the action, oftentimes you're cutting more than you're adding. That's my
Mm-hmm.
view. We had
Yep.
other witnesses that we're thinking about calling. We go home at night and we go, cut them,
Yeah.
do less, do less, do less. And I think you have to weigh and measure the momentum of a jury. And I think you made a really good observation about how the case kind of skidded to a stop in the defense's case in chief. And and I love I love to put on, and they're now going to watch this and try and change their strategy. But I love to put on that disparate showing
Yeah.
because I like to be able to get up and rebuttal. And oftentimes in cases, I'll say, look, we did everything we could to get you every little piece of evidence with every minute that we had that the judge would give us. And we went, and I've had cases where I say, we went to 6:30 at night just to get you that one guy that was going to tell you that one thing, and then got him off the witness stand. And then what happens? We hand over the case, and, we had a late start. We got a 3-hour lunch. We don't even have evidence on a Monday. Let's get to the truth. Let's get to what really happened. And if you, the defense lawyer, think adamantly that the truth was on your side, then why'd we spend a day and a half doing nothing? Twiddling our thumbs.
Kevin, don't worry. It doesn't matter if they watch it. They're not going to change because they can't. It's just too big of a machine. Like it just is what it is. Like, I don't think they try to do that. It's just how it happens because, God forbid you finish half a day early on a case. I mean, that's really all it felt like it was, is like half a day early. And that's just how it happens when it comes to delays and preparation. And I think sometimes they think their strategy is better. Like, delay it, make it seem boring, let them forget what the plaintiff put on 2 days ago, go over the weekend. So, I think it's just kind of a difference in philosophy and strategy. But I think, hey, if I can encourage you to keep doing what you're doing, I don't think you need that encouragement, but if I could, I'll give it to you because I enjoyed the way you presented it. I thought you came across as somebody who is honest and credible and believable. And as a plaintiff's lawyer, that's really all you can come off as. I think you still came off as very intelligent, put together. And some people don't like that. They like, oh, ho hum, I'm just a country lawyer. You don't have any of that in you. Which, is the style I like, but it's not like you came over the top or were screaming at people or telling them they had to do a certain thing. So I thought it was amazing. I loved watching it. I'm a fan. I'm somebody who learns from you now and will continue to do so. So I really, really appreciate you taking the time to come on the channel, and I'll link your, Instagram or your website or something on here so that everybody can go and find, because I know you're also doing a lot of other things. We didn't have enough time today. We'd be here for 3 hours. There was multiple things I wanted to dig in more with you, but I know you're handling some other high profile cases I saw on your Instagram now, because I follow your Instagram. What is your handle? I don't know what it is. I follow it, but
It's just my name. So as it's read there without a space. Yep.
Perfect. All right. So go follow him on Instagram. He's got a lot of other cool cases coming up. I'm sure we'll be asking about them and talking about them, but I really appreciate you coming on, man.
I really appreciate it. Happy to be on, and thanks for the invite.
All right. Until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.